Ladies and gentlemen, my name is Arunjeev Singh. I will be giving the presentation today for the CPD seminar. As I was discussing, the immigration instructions are quite complex and needs hard time and lot of efforts to understand the implications and the underlying purpose and the objective of the immigration instructions. So I have compiled the presentation in my own simple words, as well as I have copied few parts of the immigration instructions verbatim, and have given few explanations in my own words to explain those instructions. So first I will touch the issue of partnership-based work visa. My thrust of today's seminar or presentation would be accredited employer work visa holders. So partners of the accredited employer work visa holders can be granted a work visa if the applicant meets the requirement of E 4.5.25 instructions to prove that they are living together in a genuine, stable and enduring relationship with their supporting partner. The supporting partner, who should be the holder of accredited employer work visa or essential skills visa, must be employed in a role that is paid at least twice the median wage, which would be 63.22 per hour, or paid at least the median wage and is on the green list and meets the instructions at Appendix 13. So I will stress on few words, so please be minded. If there is and, it means it has to be complied. If it is or, it might be alternative of that, could be an option. So I will repeat this particular instruction. The supporting partner, who should be an accredited employer work visa holder or an essential skills work visa holder, must be employed in a role that is paid at least twice the median wage, which would be $63.22 per hour, or paid at least the median wage and is on the green list and meets the instructions at Appendix 13, or the supporting partner must be employed in a role classified at skill level 1, 2, 3 as per ANZ SCO and paid at least the median wage, or paid at least 1.5 times of the skilled migrant category median wage, or employed in a role under the transport sector or care sector work to residence policy, which would be referred as SR 6.10 or SR 7.10, and paid at least the median wage. So there are many ands and there are few ors. So it means the policy is quite complex. You have to go through the appendix, as well as you have to go to the current median wage and calculate twice the median wage. So this is a little bit of exercise which every immigration professional needs to undertake before they advise a particular applicant or potential applicant. The supporting partner must be employed in a role classified at skill level 4 or 5 and paid at least median wage if on 26th of June 2024 and the applicant held a partnership-based visa of accredited employer work visa holder, or their application was under processing, which was later approved. Work visa cannot be granted to any partner of the accredited employer work visa holder if the supporting partner is paid less than the median wage, which was 29.66 per hour, or whose employment is at skill level 4 or 5, unless above 2 to 4 conditions apply. So immigration instructions also refers in the same manner, pointing out who is eligible and then pointing out who won't be eligible, which confuses the whole scenario if a person has to understand in a layperson's language or a layperson's mind. So I know immigration officers, they are as confused as we are, and there might be something interesting for the immigration professionals if they have a insight and understanding of the underlying object of that particular policy, and if there is any negative impact or any negative concern raised by immigration officers for their clients, they can get advantage and benefit of today's seminar while we are discussing. If you have any point or any clarification to add, you are most welcome at the end of this seminar. You can note down a point and then you can add on, or you can ask for a clarification at the end of this seminar. So conditions of partner's work visa. The applicant may be granted work visa subject to conditions that the holder must only work for an accredited employer who holds accreditation on the visa start date or on the date of job offer, and either paid at or above median wage as on the date of start of visa, or in a role earning at least the relevant wage threshold if an uncapped sector agreement is in place for that role, as on the date of start of visa or on the date of job offer, and not work at below the median wage in a role offered under the capped sector agreement, which would be policy WA 3.15.5. So now I will repeat that this is complex scenario. We have to go to check what is uncapped sector agreement and what is capped sector agreement. So it's not easy for any advisor or a lawyer to immediately and in a short words explain whether a partner is eligible and what conditions would be imposed on their visa, because if a layperson makes any statement, that won't be taken as advice and there won't be any consequences for any wrong advice. But if as an immigration professional we are giving any advice which is ultimately inconsistent with the policy, that's going to make a huge difference in our competency and could raise a concern from the client. So I would request every person who is attending today's seminar, please make sure you take few minutes or spend some time to go through what words have been used and to get the explanation or relevance of particular agreement or this capped or uncapped sector agreement. Note, the potential employer need not have been granted a job token by the Immigration New Zealand, but only accreditation which was valid on the date of start of the visa or on the date of job offer. Now, determining the wage rate of the supporting partner. Supporting partner means the sponsor. The supporting partner, who should be the holder of accredited employer work visa or essential skills work visa, must hold the median wage rate if their remuneration has increased after the grant of their accredited employer work visa. Evidence must be provided by the applicant to prove by way of either individual employment agreement or a letter of confirmation from the employer confirming the increased wage rate, and full bank statement and IRD summary of earnings or their pay slips. So if you want to give complete evidence and expect a decision to be made quickly, then it is advisable to provide the documents at the time of filing. If the sponsoring partner was not holding the current median wage at the time work visa was granted to them, and later on if the remuneration has changed or increased. So then there is another category of visas for the partners, which will be a visitor visa. So partnership based visitor visa for accredited employers, employer work visa holders is at V3.10.1. If the supporting partner, who is the holder of accredited employer work visa, is employed in a role at skill level 1, 2 or 3 as per ANZ SCO, or paid at or above 1.5 times of the skilled migrant category median wage, which will be referred to as SR 3.20A sub clause 2, or employed in a role on the green list and meets the green list requirement at appendix 13, or employed in an acceptable employment under the transport sector or care sector work to residence policy, which will be referred as SR 6.10 or SR 7.10, which we will discuss in today's seminar few minutes later. If the supporting partner, who is the holder of accredited employer work visa, is employed in a role at skill level 4 or 5, and the applicant was holding a partnership based work visa, on 26th June 2024, or on this date their application was under process and was later granted, then the partner can be granted a visitor visa. The period of work visa for the applicant, who is the partner, shall be the same as their supporting partner's work visa expiry date, subject to generic meeting the generic requirements of living together and having acceptable standard of health and character. Applicants applying for a partnership based visa after 26th of June 2024, an applicant who is a partner applying for the visa applies a visa after 26th of June 2024 shall not be granted a visitor visa if the supporting partner, who is the holder of accredited employer work visa, is employed at a role of skill level 4 or 5 as per ANZ SCO and not paid 1.5 times of the SMC median wage, or employed in a role on the green list and meets the requirement of appendix 13. So there is a categorization of the sponsoring partner and their eligibility to support an applicant for a partnership based visitor visa. Next category is partners of the holders of migrant exploitation protection visa, which is called MEPV and which is referred to as WF 3.1C. Partner of the holder of MEPV can be granted work visa based on their partnership only if they held a partnership based visa supported by the holder of MEPV before, and then they may be granted a special work visa as a partner of the holder of MEPV. So it means that if they were holding a partnership based visa before, their partner applied for a migrant exploitation protection visa, only then they can be granted a work visa on the basis of the sponsorship of their partner who is currently holding migrant exploitation protection visa. Now I will come to the second topic of today's seminar, which is work to residence visa. But before moving to that part, if there is any question or anybody who wants to add on to what I have explained in my presentation, you are most welcome to ask. Yes, Mr. Vinod Junejaji.
Sir, suppose if a person is holding a AEWV visa and the partner is holding a partnership-based work visa, but later the AEWV visa holder applies for a MPEV, and what will happen to the partner's visa? Do they need to apply for a new one, or because their visa was already there?
No, they have to apply because their sponsoring partner circumstances and the category has changed, so they have to apply another visa based on the sponsorship of their partner once their partner is holding a migrant exploitation protection visa. So that is very clear, they have to apply.
They have to apply.
Exactly, they have to apply. It can't be automatically considered as a visa of a partnership based of a holder of AEWE. It has to be applied.
If they get the migrant visa, then the partner will have to apply.
And they have to apply, and only then they will be granted, and it will be granted for the same period as their sponsoring partner has.
Because the circumstances have changed.
Because their circumstances have changed, because the category of the sponsoring partner has changed. So they have to apply. It's automatically can't be transferred at all. Any other question, please? Yes, Madhu Behel.
Sir, I'm a bit confused in this page of 3.101. Here it says supporting partner holder of AEWE is employed in the role skill level 1 to 3, or paid above 1.5 the medium wage. So this is pretty much similar to page 1. So what's the difference?
Yes. So the difference is only the cutout date is 26th of June 2024. That is the only difference. In work visa, there is no cutout date.
Yeah.
The cutout date is on visitor visa of 26th of June 2024. Their partners must hold a particular category of visa with the remuneration or with the green list and all those requirements. So that is the main reason it has been incorporated twice in the policy. If you look at the work visa policy, there is no date of 26th of June.
Yeah.
It is only under this V 3.10.1. This date is mentioned. Any other question, please? Online speakers, if you have any question, please send a message, then we can ask you to ask the question. Okay, otherwise I will move on to the next category, which is work to residence visa. So there are few categories and subcategories now for resident visas. So first is talent accredited employers work instructions, which is called WR1. Then WR2 talent arts, culture and sports work instructions. WR3 long-term skill shortage list work instructions, and then this accredited employer work visa, and then WR5 skilled migrant category job search instructions. So SR5 is the relevant instruction for work to residence category. So this category is subcategory of the residence visa categories. SR5, SR6, SR7, these are all subcategories for the resident visa. So SR5 applies for an applicant who wants to apply this visa, and there are qualifications required to apply this. First is you must be currently working or have a job offer. Second, from an accredited employer. So coming to the topic, at the time you apply for work to residence category, you must be working for or have a job offer from an accredited employer, and your employment must be full-time and permanent or fixed term for at least 12 months. You must have worked for 24 months in a green list tier 2 in demand role. So there are number of qualifications before an applicant can be considered as suitable person to apply for work to residence category. So in other words, Immigration New Zealand has put a brake or put a lever in front of the people who are currently on accredited employer work visa or skilled migrant category work visas, and then only after 24 months of working in the green list tier 2 occupations, they can apply for the work to residence, their resident visa. So to be granted a green list work to residence visa, all applicants must meet health and character requirements for residence and meet the applicable minimum standard of English, or where instructions allow pre-purchase English for speakers of other languages tuition. In addition, the principal applicant must hold a work visa or a critical purpose visitor visa with work condition at the time the residence application is made, and meet acceptable employment requirements in a tier 2 green list occupations, which is at SR 5.10, and have completed 24 months of work in New Zealand in a tier 2 green list occupation, which is at SR 5.15. And the maximum age limit for applicants should be 55 years or younger at the time the residence application is made. To demonstrate that the applicant meets the requirements for the green list occupation, which is at Appendix 13, the applicant can provide the following documents: the qualification documents, and if the green list requirement is for a New Zealand qualification and the qualification is from outside New Zealand, an international qualification assessment, which is called IQA, from the New Zealand Qualification Authority. Note, an IQA assesses an overseas qualification by stating the learning outcomes of the closest New Zealand equivalent qualification and states the NZQF level and qualification type of that equivalent qualification, and refers to any verification of the applicant's qualifications undertaken by the NZQA. So they need to provide the registration or professional membership if that occupation requires, and documentation confirming registration or professional membership should be provided. Acceptable employment in a specified occupation, the employment agreement and job description specifying the occupation must be provided. Acceptable work in New Zealand, evidence in the form of employment agreement and job description, previous and current if there are different job descriptions, stating the duration of the employment, position and remuneration, and a summary of earnings from IRD confirming a period of at least 24 months work. Pay rate should be provided and evidence should be given in the form of employment agreement, a summary of earnings from IRD, and the bank statement of the applicant showing receiving particular amount of wage rate. In cases where any of the details listed in SR 5.5.1 have changed since the applicant's most recent work visa application, and these details are material to their application, for example, their remuneration has changed and they are relying on work in New Zealand in a role paid at least twice of the median wage, an applicant must include the evidence of the changes as set out in SR 5.5.1a. An immigration officer may consider evidence and information provided in previous work visa applications to determine whether the applicant has a total of 24 months of acceptable work experience in New Zealand or meets the requirement specified in the green list. So there are very strict and specific requirements to be followed if an applicant has to apply under this category. Then in respect of the English language ability, the applicant has to provide a certificate of IELTS or any other equivalent competency certificate not older than 2 years, and it must be overall 6.5 bands for the principal applicant and 5 bands for the secondary applicant. Now, acceptable employment in a Tier 2 green list role. So all other requirements, I would say, are kind of secondary for the immigration officer, but as we have noticed in our previous dealings with the Immigration New Zealand, assessing the skilled migrant category resident visa applications, they were very, very strict, or I would say conservative in their approach on assessing whether a particular job is of a particular category and meets the requirements of the ANZ SCO. So similarly, in this category also, we expect the immigration officers would be too conservative in having clear view whether the applicant meets the requirement of acceptable employment in a Tier 2 green list role. So it's just not that the applicant can claim and the immigration will accept it. So they have used the word acceptable. By using this word acceptable, they have given an indication or a clear statement that unless we are satisfied, we won't be accepting what you claim. So that is very, very critical for every immigration professional to point out to the immigration officer when they are filing this application on behalf of their clients. Acceptable employment in a Tier 2 green list role is employment where the immigration officer is satisfied that the principal applicant holds current employment or an offer of employment for an occupation listed in Tier 2 of Appendix 13, and the requirement of the principal applicant's occupation specified in Tier 2 of Appendix 13 are met. The remuneration for the employment or offer of employment is either at or above the hourly rate specified in Tier 2 of Appendix 13, where an occupation has remuneration requirements, or the remuneration is at or above the median wage of $31.61 per hour, and the employment or offer of employment is with the employer who is accredited and their accreditation is not suspended at the time the residence application is either made or decided, and the employment is full-time, at least 30 hours guaranteed weekly for every week worked, and the employment is permanent, and the employment is genuine and is not offered as a result of payment. So there are many ands, there are few, I think there is no or. So acceptable employment is also I would say challenge for every applicant who wants to apply under this category, and it is our duty to make sure the documents produced by the applicant meets all these requirements. Despite a subclause A1 above, acceptable employment also includes current employment in an occupation that was previously listed on the green list at some point in the applicant's 24-month period, and the applicant has completed 24 months in work in New Zealand in that occupation. For roles that do not require occupational registration, an immigration officer may be required to assess whether the employment matches the green list occupation. In determining whether employment is for a role on the green list, an immigration officer may undertake a substantial match assessment. So coming to the point of acceptable employment in current role, so it says that if an applicant is holding a green list role which is meeting the requirements of Appendix 13, and later on their occupation was removed from the green list, they will still be eligible to apply if they are able to prove to the satisfaction of the immigration officer that their occupation was previously listed in the green list. First thing, they have to prove that they have completed 24 months in that occupation and have got the remuneration described in the Appendix 13 for that particular occupation, and that this occupation is no more in the green list tied to occupations. So there are few tests which the applicant needs to provide to the immigration officer if they have to consider to apply for considering this job offer or an employment as an acceptable employment. So now little bit detailed in about this particular thing. SR 5.15, which says the requirement of 24 months of work in New Zealand in Tier 2 green list role. Applicants must have worked for at least 24 months in New Zealand in an occupation on Tier 2 of the green list on and after 29th of September 2021. To be considered as having worked in a Tier 2 green list occupation, applicants must have met the requirements for their occupation as specified in the green list for the duration of the 24-month period. For example, if there is a requirement that a teacher or a doctor or any other occupationist has to meet the registration requirements, and within 24 months they have a suspension of their registration for few months, that won't be able to be considered as meeting that requirement. So they must hold the registration requirements if they have to qualify for the 24 months of work in a particular green list role. For the 24 months of work in New Zealand, the applicants must have been working full-time in that occupation and held one of the following visas, which is, it could be any work visa, it could be a partnership based work visa either, or a critical purpose visitor visa with work conditions, or an interim visa granted while the applicant held a work visa or a critical purpose work visa with work conditions and applied for a further work visa. The 24 months of work must be gained during the 30-month period immediately before the date the resident visa application is made. So that is also critical. We need to dig on few things from the client, whether the requirements they are claiming have been met as per the immigration instructions. So I am again repeating for the sake of brevity that there are so many technical complexities involved, and we should not mechanically or without applying our mind give any advice to any client or potential client over the phone that they meet a particular requirement and they can file it, because there have been cases in the immigration advisors disciplinary tribunal where the immigration advisors gave the advice you can apply, but later on the client applied and got the decline and advisors competency was under question. So it is always advisable for every professional to just not mechanically advise for the sake of getting money and then file the application, and later on if it fails there will be certainly a consequence to follow, because now all the registering bodies or licensing bodies, they are very strict in checking the compliance or competency requirement of a particular advisor or a lawyer. So that's why I am repeating again and again that policies are very, very complex. So many ifs and buts are including, so many ands and ors are included. So we need to sit with the client for a period of time, dig it all the information from the client, and then give a opinion or advice whether they meet the requirements or not. So this policy has been designed to make it more difficult for the applicants to meet, so that there would be a break in the number of applications filed under every category with the Immigration New Zealand. So please, that's a caution that we need to act with due diligence and show our competence, get the proper information and see the documents which the client has submitted to us, and on that basis we should give the proper advice. So there are a lot of ends which have to be joined together and see whether your client meets all those requirements or not. Moving forward, where an occupation has a remuneration requirements, the work period will start to be counted when the applicant's remuneration reaches the hourly rate specified in Tier 2 of Appendix 13 for that occupation at that time, provided they hold a visa described in C above. So what does it say? That the 24 months period can't be counted without looking at the whole scenario about the remuneration, about the tasks, about the registration requirements, about the those ANZ-SCO requirements. Everything must be assessed and looked at before assessing whether the 24 months of work experience is acceptable or not. So that's why they say where an occupation has a remuneration requirements, the work period will start to be counted when the applicant's remuneration reaches the hourly rate specified in Tier 2. Suppose the Tier 2 Appendix 13 says your wage rate must be 31.61, and at the time the person claims it was 29.66, and he says I need to be counted because I was getting the median wage of that time, right? So that needs to be assessed, because it says the work period will start, the qualifying period, actually it is a qualifying period of 24 months. It will start to be counted when the applicant's remuneration reaches the hourly rate specified in Tier 2 of Appendix 13. So if Tier 2 Appendix 13 says it should be 31.61, even if he was getting the median wage at that time, it doesn't matter. He doesn't qualify for that qualifying period. So those things needs to be assessed by the advisor before giving the advice to the people. Where an occupation does not have remuneration requirements, the work period will start to be counted when the applicant's remuneration is at or above the median wage at that time, provided they hold a visa described the C above. The work period while earning the specified hourly rate will stop being counted if the applicant ceases to hold one of the visas listed in C above, or the applicant changes employment and their new income is below the median wage at that time, or the hourly rate specified in Appendix 13 for that occupation at that time, or the applicant's remuneration decreases and the new rate is below the median wage at that time, or the hourly rate specified in Tier 2 of Appendix 13 for that occupation at that time. So a table showing the median wage rate and the wage rates for green list Tier 2 occupations with remuneration in effect across time is set out under SR 5.15.1. Note, where remuneration requirements apply, work in New Zealand will not stop being counted if the specified hourly rate in immigration instruction increases as long as the applicant's income does not decrease and they have not changed employment. For example, a crane operator must be paid an hourly rate of 1.3 times the median wage. An applicant can start counting work experience from 29 September 21 if they earn 35.10 an hour, which was 1.3 times the median wage at that time. When the wage requirement increases to 35.96 an hour on 4th July 22, they can keep counting their work if they are still in the same job earning 35.10 an hour. So it means that if they started counting their 24-month qualifying period, they must be earning 1.3 times, which was the minimum requirement for that occupation. If they are not earning, they say we earn median wage, so then they are not qualifying, right? Many people, they say that we were getting the median wage at the time we applied, so which was 29.66. But if the tier 2 occupation says, appendix 13 says that their remuneration must be 1.3 times, they must hold that. If they are not holding it, they are not counting as the qualifying period. So that's why we have to get all these things very, very carefully and then assess whether it is meeting the qualifying period or not. So then SR 5.20 is work in New Zealand earning at least twice the median wage. And then they have a chart which says twice the median wage rates in effect across time are 29 September to 21 to 3rd July was $54 per hour. Then it was 55.52, then it was 59.32, then it is 63.22 from 28th of February onwards. So what I said again, I will repeat, that this policy makes difficult for most of the people who are on accredited or any other visas to qualify for work to residence. And then if they meet, it would be after a gap of 24 months and maybe more than that for few applicants. So I won't go on detail for this. I will jump to now SR 6.1, which is care workforce work to residence subcategory. The objective of this category is to provide for grant of resident visas to people who have worked in New Zealand for at least 24 months in a care workforce sector occupation list in Appendix 14. So now you need to look into the Appendix 14 as well. So it's not easy for every immigration advisor or a lawyer to immediately look at Appendix 13 or Appendix 14 and move in between the policy requirements, which is acceptable, which is the remuneration period, what median wage was applicable at that time, green list tier 2. So there are a lot of exercises which we need to do. So summary of requirements I have mentioned here. So SR 6.10 says acceptable employment in a care workforce sector role. It says acceptable employment is employment where the immigration officer is satisfied that the applicant holds current employment or an offer of employment for an occupation list in the care workforce sector occupation listed in Appendix 14, and the employment is paid at or above $28.25 per hour or the equivalent salary, and the employment is with the employer who is accredited and their accreditation must be active at the time the residence application is either made or decided, and the employment is full-time, and the employment is permanent, and the employment is genuine. Now SR 2.1, which means how to assess the employment, whether it is substantial match.